right, Kate. Hello, everyone. Good afternoon or good morning, depending on where you are. Thank you so much for joining us for our OVW webinar on policy developments affecting immigrant survivors. For those of you who don't know me, my name is Kelly Head. I'm a staff attorney at ASISTA, and I use she, her pronouns. I'm joined for today's webinar by my colleague, Cristina Velez, Legal and Policy Director at ASISTA, as well as our partners, Yasmin Campos-Mendez, Public Policy Manager at Esperanza United, and Grace Huang, Director of Policy at the Asian Pacific Institute on Gender-Based Violence. A few housekeeping matters before we start. Today's webinar is being recorded, and the recording will be sent to all attendees in the coming days after the webinar. All of the materials, including the slides, were emailed to attendees earlier today. If you do not have the materials, you can request them by emailing ASISTA's Program Associate, Maria Lazarino. Maria's email is manager@asistahelp.org, and I am also popping her email into the chat. This webinar is pending approval for 2 CLE credit hours in Texas. If you are barred in Texas, we will submit your CLE credits on your behalf. If you are barred in a different state, or if you are a DOJ accredited representative, please email Maria to request a certificate of attendance to submit on your own behalf. Please ensure that your complete first and last name are included in Zoom if you're seeking CLE credit. One note on accessing the hyperlinks in the slides today. Whenever you see a hyperlink on a slide in PowerPoint, go ahead and right-click on the hyperlinked text, scroll down to the word hyperlink, hover your mouse over that word, and then click Open Hyperlink. As Mary Kate said, we do ask that you please use the Q&A box for your questions during today's webinar. Please use the chat box only to interact with each other, to answer our questions, and to voice your thoughts on today's presentation. We will try our best to take your questions today, but if we do not get to your question, please feel free to review the third to last slide, which explains how to get in touch with ASISTA for technical case assistance. Finally, I would like to take a moment to thank the U.S. Department of Justice Office on Violence Against Women for their support of ASISTA's training and TA work. Without OVW support, today's webinar would not be possible. Now let's get started. Next slide, please. So our learning objectives for today, the hope is that by participating in this webinar, you will be better able to, number one, understand both big picture and administrative policy developments that affect immigrant survivors. And number two, that you'll be better able to navigate the practical implications of these policy developments for the immigrant survivors that you serve. Next slide, please. We'll start out with the big picture policy updates today. We'll then transition into no less important administrative updates, and then we'll have time for Q&A at the end. Next slide, please. And next slide, I'll turn it over to Yasmin.
All right, great. Hello, everyone. So I'm going to be talking a little bit about some of the administrative responses to the immigration challenges that we've seen this year. So on March 30th of this year, USCIS announced the opening of the Humanitarian Adjustment, Removing Conditions, and Travel Documents known as the HART Service Center. And it's the first to focus on humanitarian and other workload cases. And so HART currently right now is working on just building the dedicated team of especially trained staff responsible for adjudications, including the VAWA South petitions, issuing the U visa bona fide determinations, and then the reunification of refugees and asylees with their family members. And so some things I wanted to highlight is the launch of the new HART Service Center, or hopeful, is a critical step forward by USCIS in serving immigrant survivors of gender-based violence. And as advocates, we really want to ensure that the employees at the HART Service Center are trained. And so what do we mean by that? We mean trauma-informed, culturally responsive, understand how complex, and I mean complex, gender-based violence situations can be, and also be compassionate adjudicators. And so this new agency is positioned to implement better the Violence Against Women Act immigration protections for survivors who currently experience these extremely long, egregious delays in processing their U visas. And so I won't go too much into each form, but just to quickly highlight the forms that will be adjudicated at the service center are the I-918 and the I-918 Supplement A for qualifying family members, which is the bona fide determination, which only allows the individual to apply for the employment authorization document, and provides for U visa deferred action, which means that the individual will not be deported for a certain period of time. And there's also the I-360 VAWA South petition, the I-730 refugee asylee relative petition. So if you've been admitted to the US as a refugee, or if you have been granted status in the US as an asylee and you were from principal applicant for your family, you may file for the Form I-730. And then there's also the I-601A, which is a provisional waiver. And so go to the next slide, please. And so why is the HEART Service Center important to advocates and survivors? And so essentially, we know that immigrant survivors are, have these significant fears of reporting crimes. They face barriers of accessing culturally and linguistically appropriate services, and they face challenges in pursuing these potential immigration remedies for gender-based violence victims and survivors. And so there's multiple forms of systemic and societal discrimination, and these play factors, right? And why there's over 300,000 individuals with pending U visa matters currently as of date. And so we know that that immigrant survivors of gender-based violence are experiencing major delays in the processing of their VAWA self petitions and their U visa petitions, and with this major backlog here. And so what does this mean, right? What's at stake here? It means that these significant delays and the lack of access to financial resources that go with these with some of these delays can put survivors and their families at additional risks of violence, exploitation, manipulation, and trauma. And so timely access to employment authorization for victims and survivors in the U visa program and the VAWA self-petition programs is critical to escape and find alleviation from and overcome some of the abuse. And so because of certain restrictions, many survivors face the waiting period without accessing support. We're hearing, especially for folks that are working with survivors on the ground and are providing direct services, that they face these waiting periods without accessing support for housing, public benefits, and even receiving direct advocacy services necessary to provide some support from and stop the cycle of violence. And so I'm hopeful that the new HEART Service Center will make processing these petitions faster. And we know that if it does improve some of the wait times, then that allows survivors, right, to qualify for work authorization sooner. But again, I just want to emphasize how important it is to ensure that the employees at the HEART Service Center are trauma-informed and culturally responsive to adjudicate these cases. And if we can go to the next slide, please. And so two big things happened on March 30th. It was interesting. So more administrative updates here. I remember actually being at the Occupational Safety and Health Administration, the OSHA UNT celebration kickoff at the Department of Labor, and then getting the alerts that the HEART service had been launched. And so on March 30th, also of this year, OSHA became a UNT visa certifying agency in connection with its enforcement work. And the qualifying crimes. And so one thing I kind of want to highlight here before going is that their qualifying crime activities that OSHA is certified to do is different from, it does have some differences that we know are helpful for gender-based violence victims under the U visa, right? So if we look at the slides there, you'll see the qualifying crime activities under OSHA are trafficking, which includes labor and sex trafficking, murder, manslaughter, blackmail, extortion, felonious assault, involuntary servitude, peonage, obstruction of justice, witness tampering, or perjury. But unlike the qualifying criminal activities under the U visa that offer protections from different forms of gender-based violence, such as rape, torture, incest, domestic violence, sexual assault, abusive sexual contact. These are the qualifying criminal activities that OSHA can certify. And so they left trafficking. It's on the website for OSHA, they just list trafficking, which is a bit broad, but that can likely be a helpful thing, but it is labor and sex trafficking. And so if we can move to the next slide. And so what are severe forms of trafficking in persons for purposes of a T visa? So again, OSHA will consider supporting visa certifications for the U and T. And so by statute, for the severe forms of trafficking in persons is the recruitment, harboring, transportation, provision, or obtaining of a person for labor or services through the use of force, fraud, or coercion for the purpose of subjection to involuntary servitude, peonage, debt bondage, or slavery, or sex trafficking in which a commercial sex act is induced by force, fraud, or coercion, in which the person induced to perform such act has not attained 18 years of age. And so what's important, wanted to emphasize a little bit here is that sex trafficking often involves sexual assault, while labor trafficking may involve dating violence, sexual assault, and or stalking. And so OSHA stated that it will consider exercising its authority to support the U visa certification request and the T visa, and kind of in 4 different ways. And so kind of just want to quickly walk that through, and then I'll start with the U and then the T, and then kind of what the next process is that goes to Department of Homeland Security. And so for the U specifically, if OSHA has detected one of the qualifying criminal activities or an attempt, conspiracy, or solicitation to commit one of the qualifying criminal, I keep getting word is a QCA, qualifying criminal activities, which I listed earlier, right? The murder, manslaughter, felonious assault, and a few others that I listed there. And then the next step would be the qualifying criminal activity arise in the context of a work environment or an employment relationship. And then they would, OSHA would need to find that there's a credible allegation of a violation of a law that OSHA enforces related to the work environment or employment relationship. And then kind of the final step for OSHA for the U visa process is that the victim or survivor has demonstrated that they have been, are being, or likely to be helpful to OSHA and or any other law enforcement officials in the detection and investigation or prosecution of the qualifying criminal activity. And then a little bit different there for what OSHA has indicated, it will consider exercising its authority to support the TVPA certification. So first, OSHA would have to identify a victim or survivor of trafficking, again, labor or sex trafficking, and the trafficking activity arises in the context of a work environment or an employment relationship, that there's a credible allegation of a violation of a law that OSHA enforces related to the work environment or employment relationship, and then the victim or survivor has compiled with any reasonable request for assistance. And then kind of after that Department of Labor process, if OSHA agrees to provide a victim or survivor with a U or TVPA certification, then OSHA will return the completed certification or declaration form to the victim or survivor and the representative, and then the victim or survivor is then responsible for submitting the signed and completed U or T certification to U.S. Citizenship and Immigration Services, USCIS, as part of the entire package, right? The entire U and T visa application package. And so the victim or survivor must demonstrate to USCIS that they meet all the eligibility requirements for the requested visa. And what I really want to highlight is that USCIS is responsible for the adjudication of the U visa petitions and the T visa applications, not OSHA. And so OSHA is responsible for the certification process. However, there's more information on the USCIS website for determining eligibility for the U and T, and then just want to strongly encourage folks to consult with the immigration legal professional. And so if we can go to the next slide there. So can a survivor be eligible if they are already waiting for a U visa prior to being eligible from OSHA's new certification process? So yes, for survivors with pending U visas in particular, it really offers, it can really offer some breathing space for just like the egregious waiting times for employment authorization. And so I just wanted to quickly share an example of how that might look, right? So a survivor could have a pending U visa from domestic or sexual violence, and then experience an OSHA certification qualifying crime. We know that many immigrant survivors, can be subjected to be vulnerable in certain workplaces. And so perhaps with a gender-based violence component at their workplace, and then may be eligible to apply through this new OSHA process with Department of Labor and Department of Homeland Security. And so advocates see this happening on the grounds. I know it's a fairly newer process, but at Esperanza United, we have our home base in St. Paul, Minnesota, and these are some things that we've been talking to our family advocacy team that provides direct services, and kind of being able to see where these forms of relief can support survivors that are already waiting. And so if we can go to the next slide, please. So will OSHA certify for sexual violence in the workplace? Well, this is one of the areas where there still needs further advocacy, right? And so the answer is maybe. And so why maybe? So OSHA will consider requests for U certifications for qualifying crimes that include sexual offenses on a case-by-case basis. And so just remembering that OSHA will also certify for qualifying crimes occurring as retaliation for whistleblowing, but the retaliation claim may have a different statute of limitations than the underlying OSHA violation, and must be tied to the complaint about the OSHA violation. And so again, it's critical, and just really want to emphasize for workers, immigrant workers, to and their representatives to consult with an immigration attorney before submitting an application for these protections, especially on some of these case-by-case basis that are not listed per se on the OSHA website or named, but may offer some form of relief on a case-by-case basis. And so if we can go to the next slide there, I'll pass it over to my colleague here.
Thank you, Yasmin. That was really helpful. I'm going to repeat some of what you said, probably, but that's good. I think we're seeing a theme here a little bit. Let's shift over to discussion of the new deferred action policy for immigrants involved in labor disputes. This is a new program that provides protection from deportation and work authorization, so-called expedited work authorization for non-citizens who are involved in workplace disputes or complaining of workplace violations. So this can happen at the same time that someone pursues a U based or T based on some kind of OSHA qualifying offense, or separately U or T offense based on completely separate facts, or also based on the same facts as this deferred action. But as Yasmin said, it's so important that there are these additional mechanisms for people to obtain work authorization and protection from deportation. So we will refer to this policy as Labor DA, but there are some more fun sounding names in use, such as DALE, which I believe originally stood for Desde Abajo Labor Enforcement, but can now stand for Deferred Action Labor Enforcement. A colleague from somewhere else mentioned that she had heard LEDAR, but I'm not sure what that stands for, and it doesn't seem to be widely in use. I'm mentioning them because I would be prepared for clients to call it different things, depending on their relationship to labor rights organizers. For example, DALE started as a campaign by labor activists. And if they're Spanish speaking or using another acronym or yet another shorthand for it in another language, I mentioned because my colleague who asked about LEDAR didn't realize that we were actually talking about the same thing. So don't worry if it sounds like you and your client are not talking about this Labor DA program. The key elements are labor rights, deferred action, and work permits. So chances are you are on the same page. Just I would inquire a little bit further with them about what they're experiencing, and then think later about what kind of category of relief it might fall into. So this policy was formally, as it says on the slide, was formally rolled out in January 2023, but it had been in development since a workplace protections memo came out earlier in the Biden administration. And we'll touch on some of these other memos a little bit later. Deferred action specifically is a term that means a formal exercise of discretion not to enforce immigration violations, and is an inherent power of immigration enforcement authorities. A person issued a notice of deferred action becomes eligible for a work permit based on that notice. Deferred action has existed in various forms for many years. More recently, formal deferred action programs include DACA, and in the U context, the bona fide determination, or BFD. You may also be familiar with deferred action from the VAWA survivor self-petition context, is often issued in connection with an approved I-360 petition. So in all of these programs, it's important to remember that deferred action is discretionary, right? The government does not have to approve any of these requests. The DACA program, for example, has eligibility rules that exclude people with 2 or more serious misdemeanors, but the labor deferred action program that we're talking about here does not have any such limitations. It only requires a balancing of positive and negative equities and documentation of an ongoing labor dispute. So similar to the other programs, it's just important that this application be prepared by an attorney or a DOJ accredited representative because of the specific importance of identifying and weighing risk factors. You might end up putting someone on the radar for enforcement that previously was not known to enforcement authorities. And so that's a very important decision to make with your client. Again, also on top of that, practitioners are encouraged to consider the guidance that's currently in place, and we'll talk about that more a little bit later also, to determine what that risk is. This includes the enforcement priorities memos, the ICE victim-centered approach, the Mayorkas memo, which we understand is now back in effect. There's no appeal for the denial of labor-based deferred action. So having a fully informed discussion of these risks with your client is especially important, like I said. Applicants for the last note here, applicants for labor deferred action who have pending oh, that's not in the actual note, but like separately, I covered that. Applicants who are for labor DA who have pending UT or VAWA petitions are covered by the confidentiality protections at 8 U.S.C. 1367. They are considered like protected people based on those applications, and will be flagged in the system when their labor DA requests come in. And this is the last note, that there are DA is good for 2 years, even if the workplace dispute is resolved during that time. If it lasts for more than 2 years, the worker can request renewal of the labor DA. Next slide. Thank you. So these are the steps required for filing an application for a labor DA. We have covered this in much greater detail in a March webinar that we did with some guest speakers. And I would encourage everyone who wants to know more or wants that deeper dive to check that out. It's available through whatever portal you use for the OVW webinars. And we can share out that information a little bit later, probably. But first, a claim covering the client has to be filed with the labor agency. If you meet a client who complains about workplace violations and you are not able to identify the next steps because you're not a labor lawyer, please do reach out to labor experts. Worker centers in your area, employment units at yours or other nonprofits, also some private attorneys. A lot of people are learning about this process currently, so do take steps to connect with them and to connect your client with them if you're not certain, or even if you are certain that there is a labor law violation happening. Second, you'll need to request a statement of interest called an SOI from in the new lingo of this process from the relevant labor agency. The SOI, importantly, does not name the client specifically, but rather acknowledges the dispute, the time period, and the workplace. I think it might be able to cover numerous people. Labor agencies are also receiving training about this process. And we have provided in your materials a link to a practice guide that contains samples of these for you to review. It sounds very different from the kind of certifications that we typically see in the U and T context. So just take a look at that and see what the difference is. This is a bit broader than that. I'm going to skip some of these details about how to apply, but again, take a look at that May webinar that has a deeper dive. These are the actual formal components of the application. A biometrics appointment will be scheduled by USCIS shortly after the application is received. And if it's approved, the whole process should take around 3 to 4 months. The DA request itself should consist of a letter setting forth the equities, meaning the weighing the sympathetic factors favoring deferred action for your client, and addressing any negative factors, including arrests, and explaining how your client qualifies for this kind of relief. Again, the practice manual included in your materials has examples and also recommends, I believe, including a sworn statement from the applicant. But take a look at that material and our webinar for more. Let's go to the next slide. Why is Labor DA important for survivors? First of all, as Yasmin mentioned earlier, having that access to work authorization is really crucial for a lot of non-citizen survivors. Also, survivors are workers, right? And workplace violence includes sexual violence, including sexual harassment, stalking, sexual assault, and rape. We have here information from a survey from the National Sexual Violence Resource Center that notes that 38% of all women and 14% of men have reported experienced sexual harassment at work, and that's from 2019. Labor DA, domestic violence survivors may also experience workplace violations, especially where there are state laws that are protective of the time that they need to go to court or deal with other related matters. Again, it's just super important to have that timely work authorization. Labor DA can be based on the same underlying dispute as pending URT petitions or separate disputes. Finally, our friends in the trafficking world tell us that the Department of Labor and maybe other labor agencies have been kind of confused about the difference between continued presence or labor deferred action, or these SOIs, and may be uncertain which folks are asking for because they've been receiving a lot of recent training about this Labor DA process. So it's important to push for them to request CP where your client is eligible, because it makes available additional benefits specifically for trafficking survivors. Continued presence may be more limited. There may be a more limited category of people can benefit from this, but it is important to know if your client is one of those people, and to explain specifically what you're asking for. I'm putting in the chat here a pamphlet from the Blue campaign about continued presence and containing information that can be shared with the agencies that you're interfacing with as part of the Labor DA process. And then I think I'll pass it to Kelly. All right, thanks everyone.
I think Yasmin, this is you.
Oh, yeah, no problem. All right, so moving on to the public charge rule. So the 2022 rule replaced, so what I'll actually do, let me back up here. I'm just going to kind of give you an overview of where we're at, and then in the next slide, I'll kind of provide you just kind of an update. So yeah, so moving into the public charge rule, the 2022 rule replaced the 2019 rule. The announcement happened in September, and it went into effect on December 23rd of 2022. And so the 2019 rule, and why this was so kind of important to see that change, especially for advocates. What we saw, especially during COVID, is that the 2019 rule created like chilling effect right at the outset of the COVID-19 pandemic, where many rightful beneficiaries, including immigrant survivors of gender-based violence, we were seeing that they were avoiding seeking critical life-saving and healing programs, such as emergency domestic violence shelters, transitional housing, food pantry assistance, sexual assault exams, and even direct counseling services out of fear of deportation, detention, or family separation. And so there was a lot of confusion surrounding the public charge that discouraged immigrant survivors from seeking the assistance that they needed to escape and recover from abuse. And so survivors, advocates, and allies just really needed this clear, consistent kind of keyword there, consistent guidelines, because it had become just increasingly difficult for them to help victims and survivors plan for their safety, so safety planning, and also to educate immigrant survivors and their rights and available resources. And so the 2022 rule really provided some of that clarity about what public charge is, helping inform immigrant survivors about the public benefits that USCIS does not consider when making public charge and admissibility determinations. And so, and just kind of who's exempt from its coverage and how it's implemented. So if we can go to the next slide, please. And so just want to provide an update of where we are. So 2022 rule replacing the 2019 rule. And so on May 17th of this year, the U.S. Senate used the Congressional Review Act, the CRA, to overturn the 2022 public charge rule. And so many advocates have found this to be just incredibly frustrating to, as there's just ever-changing nature of the public charge rules and how it's created just these uncertainties that I just spoke about, right? And kind of this chilling effect, leaving immigrant survivors feeling unsure of their eligibility and access to things like Medicaid, SNAPs, and other public programs. And so kind of the state of debate and where we're at, right? Just kind of that update is that the U.S. House may vote on the Congressional Review Act, the CRA, any day. It hasn't happened yet, and so kind of what would be the next steps after that. President Biden, depending on how that vote would happen in the House, President Biden could veto the CRA. And just this year and forth around the public charge role and Congress and the courts just really has led to this ongoing confusion for immigrant communities, resulting just in many immigrant survivors declining the access to these programs. And so we know as advocates and many of us survivors, right, that all survivors deserve access to safety and shouldn't be discouraged from accessing emergency shelter, safe housing, healthcare, food, or other basic needs out of the fear that doing so may harm their immigration status. And so some of the things that we have heard and seen on the ground is just really striking is that it's led survivors to be fearful to seek even things like rape kits and counseling services, which wouldn't fall under the public charge role. And so if we can go to the next slide, please. And so we wanted to talk kind of tying in these benefits and what immigrant survivors can access is to talk kind of leads us into what Lift the Bar is and what some of us in the gender-based violence work are advocating for, and tying this into how this supports survivors. And so we know that there are restrictions in the 1996 welfare reform and immigration laws barred public benefits for many immigrant survivors, such as eligibility restrictions in the supplemental security income, so SSI, and food assistance, which I mentioned, SNAP, right? So the Supplemental Nutrition Assistance Programs, which provides those food benefits to low-income families to supplement their grocery budget, and they can afford nutritious food, essential into health and their well-being. And then in addition, there was limitations in immigrant access to federal housing programs, as well as the 5-year bar to access to programs such as the temporary assistance for needy families, so known as TAMF, and Medicaid programs. And so TAMF is super essential too, because it provides cash assistance, right, to families in need, along with a suite of services to facilitate path for success. And so so kind of where we're at right now is that on June 15th of this year, it was introduced, and just going to quickly go over some of the benefits and what Lift the Bar Act would do for immigrant survivors. And so it can be, you know, making the difference between a survivor being able to access safety, and some of the benefits I mentioned, or feeling that they have no other choice than to stay in or be in abusive situations, and kind of the trickling effects from that trauma that comes with that. And so and then it also would allow immigrant survivors to meet their basic needs, such as food, housing, healthcare, and childcare. And if we can go to the next slide, please. And so kind of tying this in a little bit more, so how does the Lift the Bar Act help immigrant survivors? So providing access to these federal public benefits for lawfully present non-citizens, which would include survivors of domestic violence, sexual assault, human trafficking, and crime victims who have sought immigration protection. So the U, visa, VAWA self-petition, and a few other forms of relief, by expanding that eligibility and by reducing barriers in the U.S. immigration and benefit laws. If we can go to the next slide, please. And just a little bit more in there. I realize some of these I've already kind of mentioned. So the access to SSI, SNAP programs, but it would, what it would do is it would expand the categories of non-citizens qualified for federal public benefits to include all individuals who are not U.S. citizens who reside in the state or U.S. territory and are federally authorized to be present in the U.S. And so this includes the addition of qualified non-citizen, and so access to temporary assistance for needy families, the Social Security block grant, and Medicaid to all qualified non-citizens, and would remove the obstacles and so there's barriers to states and local jurisdictions who want to provide access to public benefits for immigrants, but who might not be ineligible for, or who might be ineligible for federal programs. And if we can go to the next slide there. I just want to make sure, is my Wi-Fi connection okay? Can you all still hear me? I got a notification that it's okay. Great. And so just a little bit more of Lift the Bar and how it would support immigrant survivors is that it would also eliminate requirements for public benefit agencies to count the income and resources of non-citizen sponsors who had provided an affidavit of support, prevents discrimination based on immigration status and child nutrition programs. Again, expands the immigrant access to CHIP, right? So the child health insurance program, SNAP and Medicaid, and it would expand federal housing programs to have the inclusion of lawfully present immigrants, including survivors. And I'll keep an eye on the chat here.
Okay. Thank you. I'm going to jump in here before Cristina goes in to flag that, you know, this Lift the Bar bill, it's been introduced in the Senate and in the House. And so there hasn't been any action, but just so you can take a look at, you know, what is being contemplated. One of the things, one of the interesting things about the Lift the Bar bill is it's also incorporated as an entire section in another bill that we didn't have slides for because it hadn't been reintroduced yet, but it was introduced last Congress, which is the Working for Immigrant Safety and Empowerment Bill. And I'm putting a link to that bill in the chat. The WISE bill sponsored by Representative Jayapal. And one of the things that this bill incorporates the Lift the Bar bill in it as a section of it, but it also eliminates the U visa cap. It requires issuance of work authorization for VAWAs, Ts, Us, special immigrant juveniles within 180 days of filing. It prevents the detention and removal of immigrant survivors that have pending immigration cases. It also strengthens confidentiality and privacy protections. So it would enhance 8 U.S.C. 1367 to prohibit information sharing with immigration enforcement unless it's for the purposes of adjudicating cases. The only information that can be shared about pending applications would be for the purposes of adjudicating applications. It would also limit immigration enforcement in certain protected areas such as courts, healthcare facilities, domestic violence programs, rape crisis centers, victim services agencies. It would also, what else would this bill do? It would do, it's our laundry list of asks for, you know, for, I don't know, I want to say over a decade and a half now of those places where where survivors have challenges accessing the protections afforded for them in the immigration statute. And so, like I said, I provided a link to last year's bill. And we know that this bill will be introduced very soon. And I think it will be the same bill within one addition of allowing for naturalization within 3 years of for those cases where you have a VAWA self-petitioner who's no longer with their U.S. citizen spouse who is abusive. And so just extends that existing provision in our naturalization law to VAWA self-petitioners. And so I just wanted to flag that for you all. And, you know, like I said, there's a link to last year's bill. And here is a link to the one pager that went to last year's bill as well. And with that, I'm going to pass it to Cristina.
Thanks, Grace. And thanks for that excellent overview of the WISE Act. And we just want everyone to know about it. It's actually a good lead into this next discussion about the case of US v. Texas and the impact on the reinstatement of enforcement priorities that applies to as survivors are considered in this on the next slide. But first, I'll give a little bit of an overview of the history of this this litigation and kind of what's important now. It's actually apologize and I want to apologize to the non-lawyers in the audience. This part is going to get a little weedsy, but there are some things that have just happened just in the last couple of days that are important for us to cover. So as some background, shortly after Biden took office, his administration began to publish a new framework of priorities for immigration enforcement, recognizing that the federal government did not have the resources to enforce every minor violation of the immigration law, and directing resources toward broad categories of enforcement that are shown here on the slide. So these categories include citizens who are considered national security risks, like, for example, people who have some, are suspected to have some link to terrorism, current threats to public safety, which I think is important to note is a narrower category than simply those with aggravated felony convictions, right? And violators of border security measures after November 1st, 2020. So in essence, those who entered before November 2020 fall outside of these priorities unless they meet one of the other two criteria for enforcement. And this sort of like current threat to public safety due to serious criminal conduct has been a really important category to draw lines around for your clients who do have criminal system contacts. At least it was until it was enjoined, and we'll see what's going to happen now that that injunction has been lifted. In September 2021, a memo by DHS Secretary Mayorkas replaced there was interim priority guidance, and that was this is the memo that was later enjoined by a district court in Texas. So the Mayorkas memo was meant to inform how all of the sub-agencies of DHS were to exercise prosecutorial discretion to enforce immigration laws. This includes ICE, Immigration and Customs Enforcement, includes the Office of Principal Legal Advisor, which is also known as OPLA, which is the prosecutor in removal proceedings. Also extends to USCIS. Before the injunction, OPLA issued guidance also called the Doyle Memo, which is included in your materials, I believe. And the Doyle Memo was to implement the revised priorities in what we refer to as prosecutorial discretion, or PD for short. When the injunction came down, OPLA clarified that the injunction applied only to the parts of the Doyle Memo that reference the Mayorkas memo, but they retain the authority to exercise PD in a case-by-case basis. So throughout this time, the other memos and guidance relating to immigration enforcement remained in effect, including the victim-centered approach, protected areas guidance, memos regarding the protection of people opposing workplace exploitation, that which I think is the source of the guidance that became Labor DA that we discussed earlier, limiting detention, memos about limiting enforcement against pregnant and postpartum people. Those were all like discrete memos that came out also around the same time period as the Mayorkas memo or shortly before, and those were not affected by the injunction. So they remained in effect while this litigation was happening. Just a month ago, a little over a month ago on June 23rd, the Supreme Court ruled in US v. Texas that the states that sued the Biden administration to stop the Mayorkas memo from going into effect, that is Texas and Louisiana, did not have standing to challenge the executive branch's enforcement decisions. So they didn't have standing. The case went. They said basically like, this case cannot continue. Case must die. Must go away. So what does this mean? Again, it's those forms of guidance that I discussed and which are on the next slide are still applicable, as is from what we understand the Mayorkas memo and the Doyle memo. So it took a month for the Supreme Court's mandate to go into effect, and some experts expected further proceedings, I think, at the Fifth Circuit, but it appears as though the government is taking the position, at least, that the Mayorkas memo is back in effect, and with it, the portions of the Doyle memo that were referenced in the Mayorkas memo, the Mayorkas memo came first. So according to Facebook this morning, OPLA attorneys in Houston, at least, were saying that in court that the previous Doyle memo is back in play. And stakeholders have been informed of this also through the Office of Public Engagement. As of, I think, the time of this webinar, the OPLA website hasn't been updated yet, but I expect that it will be very soon. Let's go to the next slide and talk about how this impacts survivors particularly. So This slide has already been eclipsed somewhat by current events, as I just hopefully reviewed with you, hopefully with some clarity. But as I noted, the Mayorkas and Doyle memos seem to be back in effect. Also, as I noted, as I said, these victim-centered approach and the additional related guidance were not impacted by the priorities litigation. Even so, outcomes were all over the place as far as how survivors with criminal legal system contexts, especially, or other complex cases were treated by OPLA. So before the injunction, individual OPLA offices also were implementing the Doyle guidance in very inconsistent ways and asking for different kinds of information for people similarly situated respondents, including survivors. So we are hopeful that as the priorities framework reflected in the Biden's, original guidance and original executive orders and the Mayorkas memo, now that that is all going back into effect, we are hopeful and will advocate for more predictability in the process, more trauma-informed and approach that is favorable to victims with arrest records or convictions. So I think that's all I have on this, but I'm sorry if it's a bit jumbled. It's a lot of information that is still somewhat in development right now. So now I think I turn it over to Grace.
Yep.
Yes, thank you.
So can we go to the next slide, please? So, as we've been talking about these various administrative policies that have been put forth by DHS, I just wanted to step back a little bit and give you a larger context. Over the last few years, since in this administration, the White House has taken on the task of trying to develop a U.S. national plan to end gender-based violence. And many of you, I know on the call, as well as, those of us in this, presentation, worked to try to inform the process of the U.S. national plan to end gender-based violence, to make sure that the needs of immigrant survivors of domestic and sexual violence and human trafficking and other forms of gender-based violence were included as part of that plan. And we have been reminded by our colleagues at the White House and the Gender Policy Council specifically that, the plan is a first step. It's a plan. And they remind us that there is still a lot of work to be done in terms of implementation. And they also reminded us that not everything that we had asked for in terms of addressing the needs of survivors of gender-based violence, immigrant survivors of gender-based violence, were included. But we can talk about that in another discussion. But in terms of what did come out in the gender-based violence plan, there's a link in the slides there, but it is seeking to advance a comprehensive whole of government and intersectional approach to preventing and addressing gender-based violence in the United States. It's, this plan is put out there in the context of international gender violence prevention work. Many other countries have such plans, and the US also wanted to make sure that it had such a plan. There are 7 pillars of this plan, including prevention, including going back to primary prevention. So, starting to address violence before it starts, providing support, healing, safety, well-being, and that encompasses, many of the services that our organizations provide in terms of resources for survivors, economic security and housing stability, online safety. Most of the immigration pieces would fit into the legal and justice system's response, emergency preparedness and crisis response, as well as research and data. So next slide. There were, next slide, please. There were some acknowledgements of the needs of immigrant survivors in the plan, though I do want to flag as we go on and talk more about some of the policy changes, later on in this presentation. It wasn't very specific, but there were some acknowledgements of the experience of folks fleeing violence in their countries of origin and experiencing violence on the migration journey and experiencing a heightened risk of exploitation and sexual violence in the United States. So there was that acknowledgement that there's a large number of folks in that are experiencing that. There are recommendations in the plan that support more research focused on victimizations of groups that have been understudied, including immigrants and refugees. There was an acknowledgement of delayed processing times and how that impacts safety and stability for survivors, including delays in access to work authorization, as well as lack of access to public benefits. There was a recommendations to enhance federal programs that provide legal assistance to survivors, including specifically noting including in the immigration legal system. One specific area where they did flag, a specific response to immigrant survivors was within federal emergency response and needing to engage immigrant and refugee organizations in those plans when emergencies occur, and then review of recent policies and administrative actions. Some of more recent ones we will cover in this presentation, and we flag this plan for you all as we're working to engage, DHS and trying to make sure that folks are aware that the White House is interested in making sure that survivors' needs are taken care of in the response in the legal system. So with that, I'm going to pass it back. Oh, excuse me. Next slide, please. So one, specific example of where, how do I put this? Of an area where there needs to be a little bit more ongoing dialogue between advocates for survivors and those developing policy is that as it relates to the recent regulation that was issued by DHS relating to the circumvention of lawful pathways regulation relating to access to asylum. Before I go very much further in describing what that regulation say, I do want to say there was a decision just last week out of California that enjoined this regulation, and so we're still waiting for that whether or not there's a challenge from the administration as to that injunction. In any event, right now, the decision is stayed through August 8th, and we'll see what happens. But the underlying regulation that was enjoined, had limited access to asylum at the southern border, if only for folks that applied through CBP One, which is an app that folks could access on their phones or electronically via computer. It also limited access to asylum only for folks who entered between ports of entry. It did provide some exceptions for exceptionally compelling circumstances, such as cases where there were acute medical emergencies or imminent and extreme threats to life and safety. In some situations, survivors may have been able to access that, though reports that we've heard from practitioners has been that really has not been a very accessible process. And then individuals that were able to access, even going through this process, if they were essentially, they could access asylum through the expedited removal process only. And so in any event, this rule has been temporarily enjoined for now, and we'll see, we won't know for at least 2 weeks, what happens next. And so I would encourage folks to follow the news, or follow our colleagues that are engaged in the asylum advocacy in terms of tracking the latest news as to what happens with this rule. Next slide, please. And speaking of rules, I just want to flag for you, we don't have any specifics yet on any of these regulations, but we know that they are in process at DHS, and we'll be letting folks know as the rules are published for engagement and your information. But we know that there is a rule in development relating to who might qualify for asylum as a member in a particular social group, as it relates, specifically relates to gender-based violence. I know that many of you are tracking that closely. And the current regulatory agenda states that the rules notice of public rulemaking is contemplated to be released in September. We will see if that happens or not, and let you all know. In addition, we are anticipating a rule making in the context of U visas, and that notice of public rulemaking is contemplated to be released in November of this year, as well as a VAWA self-petition proposed rule that is contemplated to be issued in December. And so we will have a very busy fall if they are all released on time as they have contemplated. So just wanted to flag those for you. I think a lot of the, at least with respect to the U and VAWA, there's also a T visa one in the mix too. It's just updating a lot of the regulations, because there have been some statutory changes in the midst of, since the prior rules were issued. So just want to flag those for your awareness, and I will pass it along to who's next. Kelly? Is it Kelly?
Mm-hmm. Yep. Thanks, Grace. Before we move to administrative policy updates, I just wanted to take a moment to offer some practice tips in light of the introduction of the Heart Service Center. We always encourage practitioners to check the filing location for forms on the U.S. Citizenship and Immigration Services, or USCIS website before you file. This year, we have seen USCIS change filing locations for survivor-based forms without notice, most recently for U adjustment of status applications. Not outside the realm of possibility that this could happen again, so it's important to make sure that you are always checking the updated location before you file. I recommend taking either a screenshot or saving a PDF of the web page saying where the filing location is on the day you file, so you have that in the event of any type of dispute with USCIS about where the proper filing location is. And just make sure that the last reviewed or updated date, which is usually the bottom of the web page, is included. If you need to get in touch with USCIS about a case that's at the Heart Service Center, right now they have said, as Yasmin noted, that folks should continue to use existing customer service channels. So that means, as of now, at least, there's no specific hotline email just for the Heart Service Center. So you can continue using the Nebraska and Vermont Service Center email hotlines that many of you are familiar with. ASISTA will post any major heart updates on our listserv, so we encourage you all to join if you haven't already. There is some information on the third to last slide that explains how you can join our listservs. Next slide, please.
I'd like to just jump in here and say something that I forgot to mention about the Labor DA, and that is that it has a dedicated mailbox at USCIS. So just keep an eye out for that, and look for that if you're thinking about filing one of those applications.
Thank you for that reminder. I believe it's at the Montclair Service Center. But yes, that's part of the reason I think that they're saying that it will be a truly expedited process, is that they do have a dedicated workforce working on those cases.
Exactly. Thanks, Kelly.
Thanks. Next slide, please. So These updates on 751 processing, they arose from an engagement that ASISTA had earlier this year with the USCIS Office of Policy and Strategy. And the questions and answers from that engagement are in your materials if you're interested in taking a look. As background, for those of you who are unfamiliar, most spouses of US citizens, or USCs for short, and lawful permanent residents, or LPRs, who were married for less than 2 years at the time they received their LPR status based on that marriage, are granted what's called conditional LPR status, which only lasts for 2 years. And generally, those non-citizens then have to jointly remove the conditions on their LPR status with their USC or LPR spouse. And that's called a joint filing requirement. However, there is a waiver available for certain non-citizen spouses, including domestic violence survivors. And that waiver is filed on a form called I-751. Some immigrant survivors might be eligible for multiple waivers of the joint filing requirement. So for example, some survivors might be eligible for a waiver based both on the fact that they had what's called a good faith marriage with the abuser, but that marriage ended. And then also because they suffered what's called battery or extreme cruelty during that marriage. We learned from USCIS that in these situations where a survivor qualifies for more than one type of waiver, that survivor only needs to establish that they're eligible under one of those waiver grounds. And that's positive because we had heard of some situations where USCIS at field offices was telling people that they had to establish eligibility under every single ground that they claimed, or they wouldn't get the waiver at all. So it's positive that they only need to establish that they're actually eligible under one ground. It's also positive that USCIS has said, again, in those situations where survivors are eligible for more than one waiver, that if they meet the requirements for the domestic violence or battery and extreme cruelty waiver, USCIS will grant the waiver based on battery or extreme cruelty. And that's really positive because the battery or extreme cruelty waiver allows non-citizens to naturalize or apply to become US citizens on an expedited basis, faster than folks who receive a waiver based on other grounds. If the survivor is approved for a waiver based on battery or extreme cruelty, the approval notice that they receive from USCIS for that 751 will specify the basis of the waiver approval. And what it will say on the approval notice is listed here on your slide. If there is no basis listed on the notice, that means that the waiver was approved on some other ground, like marriage termination or extreme hardship. Next slide, please. Since it's unnecessary to establish, that you're actually eligible, and based on all of the grounds applied for, the best practice is to apply for all waiver grounds that, you can make at least a colorable argument of eligibility for. And the reason for that is that the Board of Immigration Appeals, which is kind of like an appellate court for immigration cases, they held in a case called Matter of Anderson that if you have a non-citizen who is placed in immigration removal proceedings or immigration court after USCIS denies a 751, the immigration judge can only review the waiver grounds that non-citizen requested initially before USCIS. So if the survivor applies for all of the waiver grounds that they're eligible for initially, that gives the immigration judge more opportunities to grant a waiver and full permanent residence to that survivor. You'll see some practice tips on the slide that for if issues arise at the I-751 interview, which USCIS said that, they may interview non-citizens if they've requested the battery or extreme cruelty waiver, again, because of the extra benefits that go along with that waiver. So clients who claim a waiver based on battery or extreme cruelty might be interviewed. As part of our engagement, we did notify USCIS of some reports that we received of interviewers making offensive comments to survivors at 751 interviews, particularly at the Seattle field office. USCIS suggested contacting a supervisor at the field office if something like this were to happen again, in addition to asking to speak to a supervisor, which is something that we always recommend. We also recommend, respectfully educating the officer about the domestic violence waiver, about the confidentiality protections, which Cristina had mentioned earlier, and which I'm going to talk about a little bit later, and the any credible evidence standard, taking detailed notes of what happened, the officer's name, what the officer said, for example, and letting us at ASISTA know about what happened as soon as possible. You might also consider filing a complaint with the DHS Office for Civil Rights or Civil Liberties, which is otherwise known as CRCL, if the USCIS officer violated the confidentiality protections at 8 USC 1367, which again, I'm going to talk about later in the webinar. And a link to the CRCL complaint form is in your materials. Next slide, please. So in the past 12 months, how often have your clients who applied for a 751 battery or extreme cruelty waiver been asked to appear for an interview? And your options are always, sometimes, never, or not applicable. I've not had a case in that posture in the past 12 months. And if you feel comfortable doing so, if you could share in the chat some details, including the field office location and whether you think that there are any characteristics that distinguish cases that get an interview versus cases that don't involve an interview, that would be really helpful. Thank you. Folks, about 10 more seconds. Okay, thank you. We'll go ahead and close the poll. So I see the vast majority of folks have said they have not had a case in this posture in the past 12 months. No one said they always see interviews, which is positive. We have mostly sometimes and never. So thank you for that, and we will be keeping an eye on this. Next slide, please. We're now transitioning to early T-based adjustment of status. Adjustment of status is the legal term for the green card process. For some background, early adjustment of status is available for T visa holders and their qualifying non-citizen family members if the main or principal T visa holder has been continuously physically present in the United States during the investigation or the prosecution of the trafficking, and that investigation or prosecution is complete in the opinion of the Attorney General. Part of an early adjustment filing is a letter from the U.S. Department of Justice Human Trafficking Prosecution Unit, or HTPU, and these are known as early adjustment letters. HTPU used to issue early adjustment letters stating that any investigation is complete as long as there was no reason to think that the investigation was still open. This year, though, USCIS told HTPU that they thought that this practice was inconsistent with the Immigration and Nationality Act. So HTPU very recently implemented a new process for early adjustment letters. And under the new process, they actually require confirmation that an investigation actually occurred and that it is complete. Unfortunately, right now, we don't have an operative definition of investigation, and we are still waiting for guidance on that. But again, they are going to require the actual existence and confirmation of the completion of an investigation before they will issue one of these letters. Next slide, please. A critical piece of advice is generally not to report trafficking for T visa purposes to HTPU themselves or to a tip line, since that might be insufficient both for T visa purposes as well as for early adjustment purposes. It also makes sense to be mindful of how many agencies and which agencies the survivor is reporting to. And that's because HTPU, as part of the process of deciding whether they're going to issue an early adjustment letter, has said that they will contact all of the agencies that the survivor reported to before they will issue one of these letters. And if the survivor, reported to 5 agencies, that's going to delay the issuance of that letter. You'll see that, again, HTPU now requires more information before they'll issue one of these letters. And to help speed up the process, we recommend providing information about the progress of the investigation or prosecution to HTPU directly when you email them to request one of these letters. Evidence of investigative steps you might consider including could be emails with police or prosecutors that show that an interview took place, police reports that show that the investigation is closed, either with an arrest or without an arrest, as well as criminal court documents showing that a criminal case proceeded after a police investigation, which would suggest that that investigation is closed. HTPU emphasizes to always include the trafficker's name when you're emailing them, not just the survivor's name, since including the trafficker's name makes it easier for them to reach out to law enforcement and try to verify the existence and completion of an investigation. If HTPU denies to issue one of these letters, they do so without prejudice, which means that you can try again. You don't have to give up on your requests for information just because HTPU denied the letter. If you are able to eventually get information from law enforcement that you can share to show that the investigation is completed, you can always try again. There is the possibility of an early adjustment denial if there isn't enough evidence that an investigation occurred and that it's complete. If an early adjustment application is denied, it will have to be most likely refiled once the survivor has 3 years of continuous physical presence in T status. So we recommend counseling your clients about this possibility, especially if it's a little bit unclear whether the early adjustment application will be approved. The Coalition to Abolish Slavery and Trafficking, or CAST, provides expert training and technical assistance on trafficking issues, and they're a really great resource to contact about this process. We have included some CAST materials on early adjustment in your index, and I encourage you all to take a look at those and to contact CAST for technical assistance if you have further questions. Next slide, please. And then to give us the most accurate data, we ask that you please only answer this question if you have actually requested an early adjustment letter since April of 2023. So assuming you have you had one of these requests denied by DOJ? And if you feel comfortable saying so in the chat, if you have had one denied, what was the basis of denial and when was the denial? Give folks about 10 more seconds to respond. Okay, so I'm glad to see that nobody has had one of these letters denied. So that is really great to know. If you do, we encourage you to contact CAST for technical assistance or ASISTA or both. So thank you for that. And we will be continuing to monitor this issue and we'll issue updates as appropriate. Next slide, please. Completely different topic, immigration medical exams. So USCIS asks non-citizens to have a medical exam with an immigration doctor, otherwise known as a civil surgeon, for some immigration applications, including applications for adjustment of status. And the medical exam results are recorded on a form called I-693, which has to be signed by the civil surgeon and then submitted to USCIS in a sealed envelope. During the last administration, USCIS created a policy known as the 60-day rule that said that civil surgeon signatures on a Form 693 were only valid for 60 days. That policy was suspended on December 9th of 2021. And as of March 31st of this year, USCIS issued a notice saying that that prior policy has been permanently eliminated. So this is a positive change for immigrant survivors who may struggle to gather the necessary documentation that they need to be able to file their adjustment application within 60 days of the civil surgeon's signature. And now that that policy has been eliminated, survivors won't have to worry about paying for, what could be a very expensive new medical exam solely because, the civil surgeon's signature is now more than 60 days old. Next slide, please. We have heard of errors on 693s that can cause problems for immigrant survivors, even if it's an error of the civil surgeon. This actually does come up a lot in our technical assistance. So it makes sense for the survivor to request a copy of the completed 693 from the civil surgeon, and for the representative to review that carefully before filing. Representatives should be checking that the civil surgeon used the correct version of the form, because USCIS will often reject a form if someone's using an outdated version, that they checked all the boxes, completed the entire form, that they included all the required vaccines and doses. This can surprisingly be an issue. Sometimes civil surgeons neglect to administer certain vaccines, and that they otherwise didn't make any errors on the form. We can't emphasize enough, of course, to only check the copy, not the original, because if you do open that sealed envelope, USCIS won't accept that medical exam. And if you get a request for evidence or notice of intent to deny from USCIS that cites that 60-day rule, which is no longer in effect, please respond timely to that and then let us know in a technical assistance request about this issue. And when you make a response to this RFE or NOID, we do encourage you to request supervisory review because of the legal error, because they should not be enforcing that old policy. Next slide, please. Safe address guidance. So this was issued in April of this year, and aims to clarify procedures for non-citizens who are eligible for protections under that confidentiality law called 8 USC 1367. The new guidance is effective on October 31st. I apologize for any confusion. It did change after the guidance was issued. So again, it's effective October 31st. Non-citizens who are eligible for protections under this law are called protected persons. Protected persons include applicants for U visas, T visas, VAWA self-petitions, and I-751 battery or extreme cruelty waivers. So, many of the survivors that you work with. And the USC 1367 has two types of protections for these folks. The first are the confidentiality protections. And this means that generally USCIS isn't allowed to share information with other people about a protected person, with some limited exceptions. And the second type of protection are called the prohibited source rules. And that means that generally USCIS can't say that a non-citizen is what's called inadmissible or deportable based solely on the word of an abuser or perpetrator, or some members of the abuser or perpetrator's family who live with the protected person, again, with some limited exceptions. And what's really helpful about this guidance is that it clarifies that these protections, both the non-disclosure and the prohibited source, apply to all immigration applications that are filed by a survivor, not just survivor-based applications. So for example, if a protected person has a pending U visa petition and a pending DACA application, those confidentiality protections and the prohibited source rules are going to apply to both the DACA application and the U visa petition. Next slide, please. So we're going to test your understanding of the guidance with some poll questions. So Javier just filed his DACA renewal application. He also has a pending VAWA self-petition based on domestic violence by his US citizen spouse, Alan. Javier's DACA application contains his new address, which he does not want to disclose to Alan. Can USCIS disclose Javier's new address to Alan? And remember, it's in the DACA application, not the U visa. So give folks about 30 seconds to respond. We'll go ahead and close the poll. Great. So the no's have it. The answer is no. And does anyone want to tell me in the chat why the answer is no? While folks are doing that, let's walk through the steps. So when you're doing this type of analysis, the first question you always want to ask is this individual a protected person? So is Javier a protected person? He is, because he has a pending VAWA self-petition. And then the second question is, does this protection that they have under this law, does it extend to a non-victim based application like DACA? And the answer is yes, because again, the protection, it follows the person throughout their time in the immigration system while the victim-based application is pending. So that means that USCIS can't disclose any information that they receive about Javier to anyone, with very limited exceptions, regardless of where that information comes from and regardless of the fact that it's on a non-victim based application. Next slide, please. So then we have Rosaline. She has a pending U visa petition, as well as an application for temporary protected status for Haiti. Her U visa petition is based on domestic violence by her partner, Carl. Carl called an ICE so-called fraud tip line under his own name and said that Rosaline lied on her U visa petition. Can USCIS determine that Rosaline is inadmissible for fraud or misrepresentation and deny her TPS application based solely on what Carl said? So what do we think? Yes or no? Could we open the poll, please? Thank you. And we'll go ahead and close it. Thank you. So again, the answer is no. And that's because number one, Rosaline is a protected person because she has a pending U visa petition. And second, the prohibited source rule, which is the one that would come into play here because we see that Carl is the abuser, whose abuse is the basis for the U visa. It does apply to her temporary protected status application because the protection follows the person. So while Rosaline has a pending U visa petition, USCIS can't find that she's inadmissible based solely on something Carl said. And if USCIS were to deny a non-survivor based application based on that prohibited finding of inadmissibility, the denial of that TPS application would be unlawful. It's almost kind of like, the fruit of the poisonous tree idea in terms of unlawfully seized evidence in criminal cases. Next slide, please. The safe address guidance, which is in your materials, contains a table with some helpful information about mailing procedures, which I encourage you all to review. This slide is about safe address procedures for applicants who are represented. In the interest of time, we're not going to go over the procedures for applicants who don't have an attorney or accredited representative, but that information is in the guidance if you're interested. The most critical piece of information from this slide is that if the representative's address is designated as the survivor's safe or preferred mailing address, it's guaranteed that all correspondence for all form types will always be sent to the representative's address. So again, if the representative's address is listed as the safe or preferred address, all the receipt notices, work permits, green cards, those will only be sent to the representative's address. Next slide, please. Our bottom line practice tip, if survivors do not want any immigration documents sent to their home, is for practitioners to designate their office address, again, as the safer preferred address. And this is because a lot of forms that survivors file with their survivor-based applications, including I-192 waivers of inadmissibility, I-765 work permit applications, I-539 applications for extension of status, as well as I-290Bs, which you would file if you disagreed with the USCIS decision. USCIS considers those non-victim-based forms, and there's different rules around who will receive the notices for those types of forms than there are for victim-based forms. So if the attorney or representative does not, if the survivor doesn't designate the attorney or representative's address as the safer preferred address on those, forms that USCIS says are non-victim based, there's a potential that, some of those documents could be sent to the survivor's home. And if the survivor has a safety concern about that, the best way to prevent that from happening is to just list your address as that safe address. Another practice tip is that a practitioner's change of address with USCIS will also change the survivor's safe address as long as the practitioner's address was listed as the survivor's safe address. And there is some guidance in there about how to properly change your address with USCIS. Next slide, please. Next, we're going to talk about some positive changes at Social Security. So previously, there was a conflict between USCIS regulations on work authorization and SSA policies. And the practical effect of this conflict was that U1s, U derivative family members, and T1s needed a work permit in order to get a Social Security number, even though USCIS says that they're work authorized incident to having that status. And this disconnect caused, really negative impacts for survivors and their family members who lacked work permits because of USCIS processing backlogs. And those negative impacts included lack of access to driver's licenses and other services that required a Social Security number. CAST, who I talked about before, they spearheaded advocacy with USCIS on this issue for T1s, while we advocated for U1s and U derivatives. And due to our joint advocacy, USCIS agreed to discuss this issue with Social Security. And after several months, Social Security changed their position and most helpfully updated their written guidance, which is called the POMS, about the documentation that's required to get a Social Security number for folks in these different statuses. Next slide, please. So now T1s, U1s, and U derivatives are in a category called non-citizens who are authorized without separate DHS authorization. So essentially now they no longer need a work permit in order to get a Social Security number. They should be able to just get a Social Security number with their I-94 that shows that they're currently in one of those statuses. As with any policy change, the change itself is only half the battle. There's still the problem of implementation, and it's not guaranteed that every SSA employee is going to know about this policy change. So we recommend sending clients to SSA not only with their I-94s, but also with a copy of the updated POMS guidance, which is in your materials, as well as a letter from Letterhead on you that explains the changes. Next slide, please. UNT-based 539s. So for background, USCIS regulations require non-citizens to be in valid U or T status when they apply for U or T adjustment. And the intersection of this rule, so rules around continuous physical presence for people who are in U status, as well as rules about eligibility to bring family members to the United States, which apply to both U's and T's. The intersection of all these rules means that some non-citizens have to apply to extend their U or their T status before they can actually apply for their green card. And they do this by filing a form called I-539 with USCIS. The processing time for this form is about 10 months, and a 539 application doesn't extend employment authorization once the status expires. So say you file your 539 4 months before your U visa expires. Once your U visa expires, you're no longer work authorized just because you filed that 539. Because of this, practitioners understandably want to file 539s well before their clients' statuses expire, so the clients can avoid these interruptions to their work authorization. The form instructions for the 539 say that a non-citizen can file this when they realize they need to extend their status, but USCIS has a policy in a policy memo saying that UNT-based 539s, the earliest they should be filed is 90 days before status expiration. But obviously that's really unrealistic given these 10-month processing times for 539s and the fact that folks' employment authorization doesn't auto-extend. We have actually unfortunately seen USCIS deny 539s based on U visas because they were allegedly filed too early. The American Immigration Lawyers Association has a committee called the UT and VAWA committee, and they recently held an engagement with USCIS where they asked about this issue. USCIS said at the engagement positively that they actually would not reject or deny a U or a T-based 539 based solely on the fact that it was filed more than 90 days before the expiration. It's obviously different than from what we've seen at ASISTA. And USCIS asked for examples of NOIDs and denials that were issued on this basis, because they were filed too early, so they can determine next steps. And in response to that, there is an open call for examples from the UT and VAWA committee and ASISTA. We're seeking examples of NOIDs and denials of U and T-based 539s that were issued during the Biden administration, so on or after January 20th of 2021, where the only reason for the NOID or the denial was because it was filed more than 90 days before the status expired. I'm popping a link in the chat to the call for examples. You could send all of the examples to me. My email is in the third to last slide, but I'm also popping it here in the chat. So just any examples you have, please feel free to share them with me, and they will likely be shared with USCIS to hopefully get a resolution to this issue. Next slide, please. And next slide. Gender designation. So this year, USCIS announced a simpler, more streamlined process for gender designations and changes. And that was effective on March 31st of this year. Most significantly, gender designations and changes on immigration forms generally do not require supporting documentation. And this is a positive development in affirming people's gender identities without requiring them to go through governmental gender change processes, which could be cumbersome and sometimes even traumatizing, especially if doing so requires the immigrant survivor to engage with systems that have harmed them in the past. Next slide, please. Gender changes can be made to pending immigration forms as well as to existing identity documents like work permits and green cards. There is no charge for a gender change on a pending immigration application, but unfortunately there is either a fee or a fee waiver needed to change the gender on a document such as a work permit or a green card. For pending survivor-based applications, practitioners can request a gender change for their client by emailing the service center hotline. You could find the appropriate hotline for your form type and service center by opening the hyperlink on the slide. Please let us know if you're having difficulty with gender changes for immigrant survivors with protected cases, but who want to change their gender on non-survivor-based applications such as naturalization, DACA, and temporary protected status, because there is sometimes issues with folks who are protected by 1367, but want to make changes to forms that are not victim-based. Next slide, please. When you're responding to an improper RFE or NOID, that is, contrary to the new gender designation policy. Just like with the elimination of the 60-day rule, we do recommend requesting supervisory review based on that legal error. We recommend, potentially, if that's something the survivor wants to do, filing a 290B for an improper denial. One example might be a denial that questions the survivor's credibility because the gender that's listed on their current application is inconsistent with the gender listed either on previous USCIS applications or other documents that they've submitted. As many of you probably know, USCIS often uses inconsistencies between a non-citizen's answers on their current application and their answers on previous applications, or between the application they're filing and other documents they're submitting as evidence. But obviously it would be, wrong of USCIS to question a survivor's credibility on this basis of the gender being different on these different documents, because USCIS, has really clearly said that there's no requirement generally that the gender on the current form matches information on prior documents. Next slide, please. And we're just wondering, have you used the new gender designation process for USCIS forms? Give folks about 20 seconds to respond. And if you have, you can let us know in the chat how it went. Okay, we can go ahead and close the poll. Okay, so it does not look like anyone's tried it yet, but just know that it's there, and there is some information in your materials about how to access this process. And of course, if you ever have questions, you can contact ASISTA for technical case assistance. Next slide, please. Before I start on this slide, I am popping a link to the USCIS webpage on the Central American Minors Program in the chat, which has a lot of really good information. I'm also popping a link in the chat to a online referral form for CAM assistance from Kids in Need of Defense, otherwise known as KIND. Some of you may have heard of the Central American Minors Program. It's known as CAM for short. CAM allows some non-citizen parents or legal guardians to reunify with their children in the United States. To be eligible for CAM, the qualifying child has to be a national of, and they have to live in one of the three so-called Northern Triangle countries, that is El Salvador, Guatemala, or Honduras. Despite the term minors in the name, CAM is open to qualifying children who are under 21 and unmarried. A child does not have to be a minor to qualify for CAM. Something very important to remember about CAM is that a resettlement agency has to submit a document called the Affidavit of Relationship, which starts the CAM process. So that's a critical difference between CAM and other types of immigration benefits where a legal services agency can apply for the benefit. There is a link in your slide as well as in your materials to a resettlement agency finder. Under the CAM process, a USCIS officer interviews the child in country, so either in El Salvador, Guatemala, or Honduras, to determine if they're eligible for refugee status. But if the child is found ineligible for that status, the child is then considered for parole. And CAM parole can be granted if there's a significant public benefit or an urgent humanitarian reason, and if the child merits what's called a favorable exercise of discretion. Cristina was talking about discretion a little earlier today. USCIS will consider both the positive and the negative factors, if any exist, in the case in deciding whether to approve the child for CAM parole. And this is the standard balancing that you're all, probably used to by now for many types of immigration cases. And if it's granted, CAM parole lasts for 3 years. Once they're in the United States, the child can reapply for CAM parole if the reasons for initially granting parole still exist. So for example, if the child was at risk of harm because of violence by family members, for example, child abuse, gender-based violence, If that risk still exists, if they were to be, deported back to the country of origin, that would be a reason to reapply for CAM parole. And unlike the affidavit of relationship, there is no requirement for a resettlement agency to submit a re-parole application. So a legal services agency can submit that re-parole application for a child who has received CAM parole and is now in the United States. USCIS recommends submitting CAM re-parole applications at least 90 days before the expiration date. Advocates are a little bit more conservative, and they recommend filing 1 year before the expiration date. So just keep that in mind. Next slide, please. Here are just some dates to help orient you to the history of the program. History has been topsy-turvy, to say the least. The Obama administration initially created the program. You'll see that the prior administration ended it, and the current administration restarted it early in President Biden's term. And the first wave of important enhancements came in June of 2021 with U1s with petitions pending on or before May 15th of 2021, newly eligible to request CAM on behalf of their qualifying children and some other family members. Next slide, please. Some important enhancements to the CAM program were recently announced in the Federal Register. Most significantly for the populations that we work with, both U1 and T1 petitioners now can be CAM requesters, and more recent petitioners are eligible. The implementation of these changes is contingent on the approval of a new affidavit of relationship form, which has not occurred yet, but that approval will be announced in the Federal Register when it occurs. We wanted to let you all know about these really critical changes to the CAM program, since they may allow some immigrant survivors to reunite with their children faster than they could through U or T-based consular processing, because of the really, egregious backlogs in U processing in particular, and the fact that, right now there's no way for folks to bring family members to the US on a U visa until they get that final approval. The CAM program may be a lot faster than bringing in that child on consular processing. That said, we at ASISTA are not CAM experts. So if you have questions about CAM, we recommend contacting Hannah Flam. She's a senior staff attorney at the International Refugee Assistance Project, who is an expert on CAM, and I just put her email address in the chat. And she has said that she's open to your questions. Next slide, please. In the interest of time, we'll go to the next slide and go back to Grace.
Okay. Yeah, I'm sure that folks will want to, I guess I'm going to go back and say if folks want to just share your most recent BFD processing times or your latest filing dates with approved BFDs. The various, I would share them in the chat. We don't need a ton, but just to give others a sense of where folks are at in terms of timelines. I know that that's always a constant question that we see on our listservs. So why don't we move to the next slide then? Just flagging a couple updates also in the regulatory space. Recently, there was a rulemaking process as it relates to providing access to the Affordable Care Act healthcare exchanges. There's a proposed regulation issue that expanded access to the ACA marketplace for individuals who have deferred action as a childhood arrival, so for DACA recipients. And the proposed regulation also included SIJ recipients and sought further comment on who else should be eligible. And some of us flagged that those that are in the who have applied for U visas that are waiting that 5 years for the bona fide determination should also be considered. And so we will see what the administration does with the comments to make sure that more folks are included in that lawfully present definition. And next slide, please. For those of you who are practicing in immigration court, I just wanted to flag this memo that recently went out from the Executive Office for Immigration Review. For those of you who may be working with individuals who've been detained in particular, who might not have had access to language access to complete forms, et cetera. I just want to flag for those of you who might be wanting to ask for more time, or you are working with an individual who might not have had assistance or in completing forms, that there is this new memo out there that reminds immigration judges that non-citizens are entitled to a full and fair opportunity to present their case, and that includes for individuals whose best language is not English, and so they need to be provided complete and accurate interpretation. And while EOIR recognizes that they've got resources in court, we know that some of the biggest challenges are for those who struggle with language access outside of court, including those who are detained. So the memo does remind them, IJs, that they need to familiarize themselves with what resources are actually available in detention facilities, and that they need to be reasonable about deadlines and consider the needs of those who are limited English proficient, and the availability of translation, et cetera, in detention facility, and noting the need for more time. And while this is just a guidance, it's not a regulation. It may be a useful resource for those who might be working to reopen cases, et cetera. So just want to flag that existence and then existence of that memo. And that's my last slide, and I'm going to pass it back to Kelly.
Thanks, Grace. Next slide, please. Oh, okay. Thank you. So we had some questions that I just wanted to address. We had one in the chat about what would happen if a U1 applicant does not have an I-94. I presume this was about the Social Security discussion. So all U1, I guess I should say, U1 people with actual final approvals, they should have an I-94 based on that U1 status. It either will be part of their approval notice that they get from USCIS when their U1 status is issued. That's the case if they were issued U1 status while in the United States. The U1 is usually at the bottom of the approval notice. If the person consular processed, meaning that they came to the United States with a like an actual U visa, and used that to enter through a port of entry, there has been some inconsistency in whether CBP, Customs and Border Protection officers at the port of entry, would give the person an I-94. What they could do if they don't have a paper I-94 from CBP is they could go to a deferred inspection office and request one. We would recommend, if you do this, that you that a practitioner accompanies the client to deferred inspection, and just asks, brings the entry documentation and requests that the person receive an I-94. ASISTA does have a practice pointer on how to request an I-94 from deferred inspection, which is in your materials. But that was a great question. Thank you. Okay, and then again, just OVW LEV grantees and STOP subgrantees are eligible for free technical assistance from ASISTA for immigration cases that are based on, related to, or arising from domestic or dating violence, sexual assault, or stalking. TA appointments through OVW are often available faster than individual private member TA appointments. So just if you're eligible for OVW TA, please keep that in mind. To get on our listservs, you can email questions@asistahelp.org. Listservs are a great way to hear from other practitioners about what's happening with their cases, their strategies, as well as to get updates from ASISTA. And are there any closing remarks from any of my other panelists? Well, thank you so much, everybody, for joining us, and thank you to my excellent panelists, and I hope you all have a wonderful afternoon. And thank you, Mary Kate, for putting the evaluation in the chat. Bye, everyone.